Hello, and welcome to today's presentation, The Basics FMLA and ADA. Managing employee leave is a complex and legally dense duty for both attorneys and human resource groups. Today's webinar will walk you through common FMLA and ADA scenarios and how to navigate them. It will also touch on how you should treat employees during the process. Before we dive deeper into today's topic, I would like to take a moment to introduce myself. My name is Stephanie Zielinski, and I'm the Marketing Director of ComplianceHR. You may recognize my name as I am the primary point of contact for the ComplianceHR and Littler joint webinars. To get ahead of our most asked questions, everyone registered for today's event will be receiving a recording of this webinar. It should arrive in your inbox within the next week. Please keep an eye out if you would like to review the recording. Now, a bit about ComplianceHR for anyone who may be unfamiliar. ComplianceHR is the joint venture of Littler and a technology company, Neota. We deliver expert employment law guidance and resources in a fraction of the time you would spend using traditional methods, because our goal is to simplify the complexity of employment law. To achieve this goal, ComplianceHR offers a suite of technology solutions around critical HR compliance topics like employee overtime, independent contractor classification, leave documents, rapid references, handbooks, and more. Today, I would like to introduce you to what we call our compliance essentials, PolicySmart and the Reference Center. Since we are all here today to learn about leave, I'll use that as my example. In order to keep your organization compliant, it's critical that your employee handbook includes all local, state, and federal leave policies. PolicySmart is able to help you add those into your employee handbook with just a few clicks. It provides additional resources like compliance timelines and handbook checklists. The Reference Center is a rapid reference tool for most employment law compliance topics. Don't use a search engine like Yahoo or Google to answer your compliance questions when you could use a tool that leverages legal data from Littler's database to ensure you're receiving the most accurate and up-to-date information. This tool recently launched a new paid sick leave report. This report allows you to view multiple jurisdictions' policies and generate state-by-state comparisons. If you're interested in learning more about either of these tools, you should see a pop-up on your screen sidebar. You may need to exit full screen mode to see it if you are interested. If so, please select yes, and we can provide you with a brief demonstration of our solutions. One of our team members will reach out to you shortly. Or at any point during today's webinar, you can let us know if you're interested by chatting us using the Q&A box. I'll go ahead and close that poll up now. So if anybody else wanted to pop in and respond, I'll give you just a second to do so. All right, it looks like answers are starting to slow down. So again, you can add it into the Q&A box if you are interested. All right, perfect. Now today I have the pleasure of introducing our presenter, Rocio Blanco Garcia. Rocio is a shareholder in Littler's Miami office. She counsels and represents clients in a broad range of labor and employment matters, including the employee life cycle from hiring through termination, which of course includes the topic of employee leave. Rocio, thank you so much for presenting today. I'll pass it over to you.
Thank you, Stephanie. Hi, everyone. So in addition to being a labor and employment attorney and a shareholder at the Littler Miami office, I'm also a little bit dorky, and my love for this topic will reveal just that. So today I'm here to talk to you about one of my favorite things, which is how to handle employees' medical leave issues. And we have titled this presentation The Basics for a reason. And that's because we only have an hour of your time today. And it is impossible for me to give you everything that you need to know about these complex laws within an hour. So my goal today is that you walk away from here with enough of an understanding to at least know what questions to ask or when to get your in-house counsel, your HR, or your outside counsel involved for assistance on how to handle FMLA and ADA issues. Another important disclaimer that I have to give is that in discussing the basics, we are mostly focusing on federal law. And the reason why I say that is because it would be a big mistake to use a one size fits all approach to any of these issues. Different states have different requirements that you must also be mindful of. For example, if you're in Florida, no big deal. Follow the federal law and you're going to be fine. But if you're in California, you have to play not only within the bounds of what the federal law requires, but also within what the state specific requirements are. Same for New York, Massachusetts, and some other states that have more liberal requirements. So today, discussing the FMLA and ADA basics, we're going to focus on issues of eligibility. What is a qualifying condition? What are the types and amounts of leave that an employee can get? Also, what are the job protections that come with FMLA? And in the context of the ADA, we're going to focus on when are you as employer on notice that an employee may need an accommodation, and how do you go about that? What does the interactive process require of you? If time permits, I will touch on other laws that interact with the FMLA and the ADA, and I will do my best to answer your questions as you post them in the chat so that this can be as interactive of a presentation as possible. I am fairly conversational with my presentations, so you may find me skipping ahead on the slides, and that might be because one of your questions has already addressed a topic that in answering one of your questions, I have addressed a topic that I plan to discuss today. So, if I'm skipping ahead, that is the reason why. All right, so without further ado, what does the FMLA provide? So FMLA is unpaid job protected leave. That is the federal FMLA, okay? In individual states, they may be paid leave protections. So it's unpaid job protected leave that you can get as an employee if you have a qualifying condition, which we will talk about in a few minutes. And you can get that leave for 12 to 26 weeks, depending on what the reason is for leave. Your own medical condition, a family member's medical condition, bonding leave, or military leave. Military caregiver leave is the one that goes up to 26 weeks. When an employee is on FMLA, they are entitled to benefits continuation. That will be something that we will touch upon today. They are entitled to job reinstatement. So please do not post their position while they're out on leave. They are entitled to come back to that position or to a virtually equivalent, a virtually identical position upon expiration of their leave. And they have a right to have their rights not interfered with, and they are protected from retaliation. One important point that I cannot emphasize enough, and that is why I have put it in red, is that when we're talking about FMLA, which is to be differentiated from the ADA, it does not matter how inconvenient an employee's request for leave might be. So for example, you might be a company that is big enough to be considered a covered employer within the context of the FMLA, but now I go on leave for 3 months, and that causes a huge problem for you because you don't have enough staffing. Now you're not going to be able to meet some deadlines for your clients. Well, the law basically says, too sad, too bad, you still have to give that leave. We don't care how inconvenient it is to you as an employer. So please do not think of undue hardship in the context of FMLA, because there is no place for undue hardship in the context of FMLA. And that is a common mistake that I see employers make. Now, moving on, how do we as employer recognize the need for leave? Well, this is another common mistake I see. Employers sometimes think that the employee needs to come up to them and be like, hey, HR, I am experiencing X condition and I need leave. And that is not the case. There are no magic words that our employees have to do. Our role as employers is to keep our eyes peeled and our ears to the ground to make sure that we are in tune with what's happening in the workplace and that we are able to identify individuals who may have a need for leave. So for example, take me. I'm an excellent employee, clearly also very modest. So I'm an excellent employee, and now all of a sudden I start not showing up to work, being late to meetings, falling asleep on the job. That should raise a red flag because that is not the Rocio that you know. The Rocio that you know is responsive and shows up. So now all of a sudden she's experiencing this she's exhibiting this odd behavior. What do I do? Well, that might be enough for you to be, hey, Rocio, I've noticed that your performance is decreasing. You are exhibiting behaviors that are out of the norm for you. Do you need leave? If so, here is the FMLA paperwork. Take it with you, think about it, and see if you need leave. You do not need to wait for the employee to start that discussion. The moment that you have enough information to be on notice that an employee may be experiencing a serious health condition, you need to start the process. Now, this is a common myth that FMLA is optional. So just a couple of weeks ago, I was dealing with one of our clients, and the client was saying, well, we offer her FMLA, but she doesn't want to take FMLA because it is unpaid. Well, she doesn't have an option. If she needs to be away from work because of a qualifying medical condition that entitles her to FMLA, then we have an obligation as the employer to certify that leave as FMLA. It has to be designated as FMLA. And if we do not do that, we are in technical violation of the law. And if we do not do that and we don't designate the leave as FMLA, later on, the employee could come back and say, well, I was never given leave under the FMLA, and we will not have a record to show that she was, in fact, given that leave. So we need to designate leave as FMLA if it falls within the scope of FMLA. This is not an option, neither for the employee nor for the employer. We have to follow that rule. If you're out of work because of a qualifying medical condition, we are going to designate that leave as FMLA, provided that you meet all the other criteria to be entitled to FMLA. Now, it is the employer's burden to designate the leave as FMLA. And if you do not have enough information, ask for it. It is important that we do not play gotcha with our employees. Under the law, if I send you as employee the paperwork and you come back to me with paperwork that is deficient in some regard, I cannot just be like, okay, too bad, I'm denying your leave, I'm marking you absent. No, I have to give you a reasonable opportunity to cure that deficient paperwork. And not only that, and this is an area where so many of our clients get frustrated because it is such a slow, painful dance sometimes to deal with these leaves and accommodations issues. So you might be saying, well, I already gave them the paperwork. They did not do what they were supposed to do. They did not submit it in a timely manner. They did not submit it in a compliant manner. Now I have given them a period to cure. So what do I do now? Well, 10 out of 10 times, you're going to hear me say, let's send what I call a last chance letter, where we unequivocally tell the employee, hey, we're giving you one last chance to comply with your paperwork requirements so that we can designate your leave as FMLA. If you do not comply, we're going to have to mark you absent, and we're going to follow our attendance policy, which may lead to your termination. We do not mince our words. We tell them straight up so that they know at that point that they are making the bed, their own bed. They are going to have to lay on it because they have decided, despite our clear notice, to not submit the paperwork. So in addition to the cure period, in order to avoid playing gotcha with employees and to just make sure that we are best positioned to defend ourselves should there be litigation, I will often tell you to do a last chance letter that unequivocally tells the employee the consequences. So just make sure that you're following those processes and that you are patient when navigating these issues, because your patience will be tested. And we just need to do this in order to protect your interest. Now, by the same token, while we are required to designate leave as FMLA if it falls within the scope of FMLA, we cannot force an employee to take more leave than is medically necessary. If the doctor has said this person only needs a month of leave, we cannot now be like, well, we want you to be out 2 months. It doesn't work that way. They only have to use what's required by their condition. So who can take FMLA? The employee needs to be experiencing a qualifying reason for leave, and we'll talk about those again in a minute. They have to work for a covered employer. Who is a covered employer? Under federal law, a covered employer is an employee that has 50 plus employees within a 75-mile radius of the workplace. Now, that is a very basic description of what a covered employer is. If we had 2-3 hours, I will tell you that the rules change for remote employees, that what is considered somebody's workplace is not as clear cut as like measuring 75 miles around. There are a lot of technical issues there, but at the most basic level, you are going to be a covered employer if you have 50 plus employees or you are a public agency, 50 plus employees within a 75-mile radius, or you are a public agency. Now, states are different, right? So if we go to Massachusetts, you are going to be a covered employer the moment that you are subject to their unemployment requirements, which is like a $200 payroll. So this is going to be significant in some regards if you are in a state like Massachusetts, right? So you have to keep that in mind. The same thing for California. There's going to be specific requirements, but as far as federal law is concerned, this is how we define a covered employer. So you have to, 1, have the qualifying condition, 2, work for a covered employer, 3, you need to have been employed for 12 months, and 4th, you need to have worked 1,250 hours in the past 12 months. Again, this is federal law, different requirements for different jurisdictions. Now, what is the qualifying medical condition? It could be the birth or the placement of a child. And we're talking about placement. We're talking about things like adoption, foster, and even guardianships. It could also be that you have to take care of a qualifying family member because that family member is experiencing a serious health condition. Or it could be that you need to leave for your own serious health condition. Those are all qualifying reasons for FMLA. Now, bonding leave, which is birth or placement leave that you get when you have the birth or placement of a child. Bonding leave is fundamentally different from serious health condition leave because the reason why we are giving you leave is not because you're actually experiencing any medical event, but rather so that you have an opportunity to bond with this newborn or with this child who has been placed in your home. Now, intermittent leave is available for for a qualifying medical condition, but it is not available for bonding leave. So let's say I am pregnant and I'm experiencing complications from the pregnancy. Any absences arising from those complications, I can take leave on an intermittent basis because that is my medical condition. Now I have birthed my child. I'm no longer experiencing a medical event. I'm just bonding with the child. Well, then now I'm not entitled to intermittent leave. Sometimes employers allow it, but you're not required to allow the employee to take leave on an intermittent basis to bond with a child. 2 weeks here, 2 weeks there. You can require them one solid block of time. Both mom and dad get to take leave under the FMLA, but please note that if mom and dad work for the same employer, mom and dad maybe have to share the 12 weeks. So they don't each get 12 weeks. Now, what is a serious health condition? So a serious health condition can be an illness, an injury, an impairment, whether it's physical or mental. So stress, depression, those can be mental impairments that qualify for FMLA. You're going to have either inpatient care, which requires an overnight stay or treatment in connection with that stay, or you're going to have continuing treatment. So when we realize that an employee may need leave and we provide the employee the FMLA paperwork, the questionnaire asks the doctor or the health provider to fill out these questions so that we as the employer can know whether the employee is experiencing a qualifying event. Now, you're not entitled to the doctor telling you what the diagnosis is. The doctor does not need to tell you that somebody is, undergoing cancer treatment. They don't need to tell you that somebody has some genetic condition. They just need to provide enough information for you to know that they are experiencing a qualifying event that will entitle them to FMLA. And as I mentioned, your employees can also take leave to care for certain family members. What family members? Their parents, their minor children, and their spouse. And I emphasize the word minor because we tend, I have a son myself, right? And I can't imagine my son needing me after he turns 18 and me not being there. But we're not entitled to FMLA to take care of our adult children unless a child has or the son or daughter has a mental or physical disability or qualifies for exigency leave. Otherwise, we're not entitled to take time off to take care of our adult children. And that is something that comes as a surprise to a lot of people. Now, grandparents, we're also not entitled as a general matter to take time off under FMLA to care for our grandparents. There are some exceptions, such as when our grandparents acted in a parental role. So let's say I did not have parents growing up. I was raised by my grandma and my grandpa. They stand in what we call loco parentis, and I am able now to take leave to take care of that grandparent. But because of that out of the norm relationship, where that grandparent really has stepped into the role of parent. But otherwise, I am not entitled to leave to take care of anybody else. Now, caring for a family member, that doesn't mean that the person needs to be unable to do anything for themselves. It doesn't require that that I be administering medication. I could take leave under the FMLA to care for my mother in the form of just providing emotional support. And that third bullet point here includes providing psychological comfort. There are some very interesting cases that touch on that subject. In fact, a daughter went to Vegas with the mom and ended up getting fired, and because they thought it was like abuse of FMLA, and the court said not so fast. She was doing this trip with her mother to provide her psychological support. Okay, so just be careful in not assuming that something is an abuse of leave. Consult with your HR, with your in-house counsel, or with your outside counsel as needed in order to make sure that you not jump into conclusions as to what is considered or is not considered providing care for a family member. And then obviously there's the concept of military leave. The employees are entitled to 12 weeks for qualifying exigency leave and 26 weeks for military caregiver leave. So if you have to care for a service member undergoing medical treatment for a serious injury or illness, then instead of 12 weeks, you are entitled to 26 weeks. Okay, I'm seeing some of your questions, and if I am not pointing them out, it's just because the answer is coming in a minute. All right, types and amounts of leave. So as I said, 12 to 26 weeks, depending on the type of leave. And this is an important point here, this second sub bullet point. Employees' own work week is the basis. So some employees work week is 20 hours. Some employees work week might be 60 or 70 hours, right? So you be careful not to say, oh, the work week is the standard 40 hours, because it is not as simple as that. I might be an FLSA exempt employee that works way more than 40 hours per week, and my work week is what dictates how many weeks, how much leave I get. So don't count by the hour, count by the work week. My typical work week of 60 hours, to make up a number, is going to be what I am entitled to, 12 of those weeks. If you are unsure what an exempt employee's typical work week looks like because they're salaried and you do not know how many hours they're working or not, get an agreement from them as to what their regular work schedule is like so that you can keep track of the leave. And this last bullet point, I think it's a very important one, and one that I come across often in dealing with these issues. Watch out for requests we may incorrectly consider an accommodation issue under the ADA. For example, an employee comes to you and tells you, hey, my doctor says I can only work 20 hours per week. As the employer, you may think, oh, this is an ADA issue. Let me go through the reasonable accommodation analysis. Not so fast. It is also an FMLA issue. If the employee needs to work a reduced schedule and he or she has FMLA available, then we need to designate it as FMLA leave. Once they exhaust the FMLA leave, then that may transition into an ADA issue. But don't just jump to the conclusion of thinking that this is an ADA issue and that FMLA has nothing to do with this. Okay. Intermittent leave, as I mentioned, typically available for serious medical conditions, not for bonding leave unless your employer agrees to provide that to you. Now, pay and benefits issues during FMLA. Somebody asked, are medical benefits required to be kept active under the ADA? Well, let's talk about the FMLA first. So when an employee is out on FMLA, one, they're not entitled to pay unless the law of the particular jurisdiction provides otherwise, or unless they have PTO or the company policy otherwise provides for paid time off for certain types of leave. But generally speaking, they're not entitled to getting paid. With respect to their benefits, the benefits continue as if they were still working. They continue at the same level, the same cost. So what that means is because they are entitled to a continuation of benefits, we as the employer need to keep our employees informed of upcoming deadlines. For example, open enrollment typically is like October, November. If I'm out on leave during open enrollment, hey, pick up the phone or call or type me an email saying, or send me a letter saying, hey, Rocio, open enrollment is coming up. Just make sure that you go through the process. Let us know if we can help in any way, because you don't want that employee to miss the deadline because they were not receiving those notifications from you. Now, employer and employee contributions remain unchanged. So let's say that right now you as the employer are contributing towards your employee's health insurance. You have your obligation is $300 and the employee has to provide $200 biweekly. That remains in place. If the employee is getting paid, whether because of state law, company policy, PTO, what have you, if the employee is receiving pay while on FMLA, you can deduct the employee contribution from the paycheck as you would any other time. If the employee is not earning money during the period of leave or is not earning enough to pay for their contribution, they still remain obligated to pay their portion, and they have to write you a check or follow whatever instructions you give them as to how to continue their payment obligations. If they don't, the law requires that we give them a 30-day grace period to come into compliance, and after that, we are typically in the clear to terminate their benefits. But make sure that you're keeping your employees informed of the deadlines, and make sure that you don't just go and cancel benefits without first giving the requisite grace period to come into compliance. So do the benefits continue while you're on FMLA? Yes, you get the same benefits as you would if you had still been working. Now, how do we go about this process of documenting and capturing an employee's request for FMLA? Well, if the employee is going to have a scheduled surgery or they're going to birth a child, like with the birth of a child, you do not necessarily know when the child is going to be born, but in a typical pregnancy, you have an idea, give or take a couple of weeks. So you can let your employer know ahead of time, like, hey, I'm going to probably be taking leave in October or November of this year. Or I have a scheduled surgery to fix my knee in December. So if the employee knows, should give 30 days notice. Otherwise, they give as much notice as they can under the circumstances. Sometimes that notice may be none because it may be an emergency. So do not be wedded to this 30-day period because it might not be possible under certain circumstances. Now, once you as employer get notice that an employee will need leave, what do? You have to provide them the FMLA paperwork. You have to provide them the notice of eligibility that lets them know whether they have met whether they work for a covered employer, whether they have met the 1,250 hours within the last 12 months, all that stuff. So that is your notice of eligibility, and you're going to provide them the rights and responsibilities, which lets them know what are their rights under the law and also what is it that they are responsible for. And finally, you're going to provide a certification form for completion by their healthcare provider, which they will submit to us as the employer for us to evaluate whether they are experiencing that qualifying event that we have been talking about, whether they are going through a serious health condition, whether they need to take care of a parent, whether they're going to need bonding leave. That is what we're going to need from them. Now, the employee, once we send them the paperwork, they have 15 calendar days to provide the certification back. If they do not provide the certification back, remember what I said earlier, do not play gotcha. Give them a chance. They have an opportunity to cure, usually 7 days. You want to give them at least 7 days to cure. And if they do not cure, you want to send them that last chance letter that I mentioned earlier. Now, oftentimes I get this question of, well, I want to contact the doctor. Well, first, you do not get to contact the doctor without the employee's consent. And second, the only HR should be contacting the doctor. There's no reason why managers or supervisors should ever be reaching out to somebody's doctor. Now, once we receive a complete and sufficient certification, we have 5 business days to designate the leave as FMLA. Remember a few minutes ago, I mentioned that if a person has a qualifying event and they're eligible for FMLA, we have an obligation to designate the leave as FMLA. So that's something that we have to do within 5 business days. I already covered this, so I'm going to skip ahead. But remember, give the employees opportunities. It is a slow, painful dance, but we have to try to do our best to give them the opportunities to comply. And please, 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 this last bullet point, send the communications via traceable method. I so many times get employers who tell me, no, I've been talking to her. I have let her know what she needs to do. Yeah, we had all these conversations, but where is the record of those conversations? When I am providing these trainings, when I am providing advice and counsel to you, I'm not just thinking about the here and now. I am thinking about what do we do if there is litigation later on? How am I going to prove that this employer that I was helping out fulfilled all of its obligations? Documentation is key. So when we're talking about the world of labor and employment, please, please, please always remember that documentation is your best friend. Send employees things via traceable method. If you can get a FedEx receipt that they received it, even better. We want to have proof that we have done our part of the deal. And please remember that you need to maintain strict confidentiality. We do not get to divulge to people who do not need to know why this employee is out on leave or not. We need to keep any information that we get regarding an employee's need for leave, health conditions in a separate file, on a leaves file. Don't put it with your regular personal documents because then you're probably not preserving them in the confidential manner that you need to. So think of this as they need to be under lock and key, whether it's virtual or whether it's a physical cabinet with a lock and a key. Just make sure that you are preserving the confidentiality. Somebody asks, for employees that are authorized to telecommute from their primary employer location, are they counted in the count towards the 50 employees within 75-mile radius for FMLA eligibility? So that's a good question. For remote employees, the guidance is that we do not look at their home, right? We look at where do they get their assignments from. So let's say that I am in Miami, as I am, and that I am a remote employee and that I get my work assigned to me from an office in Texas. Obviously, Texas is more than 75 miles away from my office, but for purposes of FMLA, my work site is going to be considered the office I get my work from, that feeds my work, that controls my work. And if there are 50 plus employees within a 75-mile radius of the Texas location, then I am going to be covered. So basically, you have to roll the employee up to a physical location that they get their work assigned from. So I hope that answers that question. Now, we have already done everything that we needed to do. We have identified the need for leave. We have provided the paperwork. The employee has returned the certification. They have been out of work for 12 weeks, 26 weeks, as the case may be. Now their leave is up. They need to return to work. What do they get? Well, they are entitled to reinstatement to the same or equivalent position. And when we're talking about same or equivalent, we're talking about virtually identical. So you don't put them in a different shift. You do not change their benefits. You do not change the location that they report to. You want to keep things the same or as close to the same as possible. If there is any substantial difference, you're going to be in non-compliant. You're going to be non-compliant. So you have to put the employee back in the position that they held. Sometimes I get companies that tell me, well, we have a need for somebody to do that job in the interim. Okay, you can work with a staffing agency. You can put somebody on an interim basis in that role. But when the employee comes back, the role needs to be there for that employee who was on job protected leave. If the role is not there, then it was not job protected leave. And if it was not job protected leave, then it was not compliant with FMLA. And remember what I mentioned earlier, to be distinguished from the ADA. Under the FMLA, we do not care that an employee's absence is inconvenient to us as employer. If they're entitled to the leave, we have to give it to them. There's no place for undue hardship. Now, what happens if the employee can't come back after the 12 weeks or the 26 weeks? Or what happens if the employee never qualified for FMLA in the first place because they did not work for an employer that was big enough or what have you? Well, cue in the ADA. So the process is not over. The employee cannot come back. We don't get to just fire them. We need to look at the Americans with Disabilities Act. Why? Leave is one form of a reasonable accommodation under the Americans with Disabilities Act. And you may be entitled to leave as an accommodation if you are disabled, regardless of whether you were eligible for FMLA or not. So under the ADA, we cannot, as employers, discriminate against employees because of a disability. And we have a requirement to reasonably accommodate qualified individuals with disabilities, unless, this is the difference from what we were talking about FMLA, the requested accommodation or would pose an undue hardship. Now we care about how inconvenient a leave may or may not be. We didn't care under the FMLA, but when we're looking at leave as an accommodation under the Americans with Disabilities Act, now as employer, we are entitled to take into account how inconvenient this leave might be to us. Are we not going to be able to deliver on for our clients? Are we going to be put so far behind that it's going to cause huge cost? We get to engage in that analysis now, because now we're in the space of ADA. How do we engage in that analysis? Well, it requires an interactive process with the employee and possibly with his or her healthcare provider. And these two last things are very, very, very key. This is a highly individualized, fact-specific analysis. 2 years ago, Joe may have not been granted leave as an accommodation. That doesn't mean that today we get to tell Susie that she also does not get leave. Why? Because 2 years ago, perhaps the company was a lot busier, perhaps the company was understaffed, and that might not be the situation today. So we need to look at the snapshot in time. Where are we as a company today? And can we today afford to give this accommodation, irrespective of whether we were able to do it in years past. If all things are equal, then yes, obviously we treat them the same. But don't assume that just because Joe did not get his leave 2 years ago, we're automatically not going to give leave to Susie. We need to look at the facts of this particular situation. We need to look at what accommodation does Susie need? How long is that leave going to be? Is going to be? Is it very unpredictable, or is it predictable that she's going to be able to come back? What is our staffing like? What are our business needs today? And that is what will guide our conclusion as to whether we give that leave or not. But the bottom line here is that the end of FMLA and an employee not being able to come back to work is not the end of the analysis. After FMLA is over, we still have the ADA to comply with. So, what is a disability? Oh, and before I move on, I see a question here. Are we able to cover FMLA leave with a temporary assignment? I think I just answered that by saying, yeah, you can hire a temporary, you can use a temp agency or a staffing company to put somebody there for in the interim, or you can use somebody from within the company and place them in that role on an interim basis. But once the leave is over and the employee is coming back to work, they're entitled to their job. Somebody else asked, does benefit continuation permit employers to collect the employee portion of premiums? Yes. As I stated, the employee has to pay their portion. If they do not, you give them a 30-day grace period to cure, and then after that, you are able to terminate the benefits. And somebody asked, what qualifies as virtually identical position when it comes to job reinstatement? I think I had a slide that mentioned some of the things, but it's basically, same shift, same workplace, basically same duties. So it's going to be, you're going to have very little wiggle room there to really change much. And I would suggest and strongly advise that if for whatever reason you're not going to put them in exactly the same position, that you immediately pick up the phone, call HR, call your in-house or outside counsel for a very detailed analysis as to whether this new assignment that you're going to give this employee would qualify as virtually identical. All right. As I mentioned, FMLA is over. We now go to the ADA. ADA protects people who have disabilities. So the key question, the bottom line is, who is disabled? Well, a disability can both be physical or mental, and it has to be an impairment that substantially limits one or more major life activities. I want you to pay close attention to that bracket, the substantially, because that will change depending on the state you're in. So if you're in Florida, this is what we're following because we just follow federal law. But for example, let's take California. California does not use that substantially language. In California, a disability is a physical or mental impairment that limits one or more life activities. So you can see how that is a more relaxed standard because it's not requiring a substantial limitation. So always keep in mind your state. Major life activity, what are we talking about? Caring for myself, showering, eating, breathing, seeing, hearing, smelling, all those are major life activities that we all do. They're basically the things that we do without even thinking about them, right? Our body just does them. So if we have a mental or physical impairment that limits a major life activity, we are going to be considered disabled under the Americans with Disabilities Act. Now, is there a list of disabilities? Yes and no. So there are certain things that we know for a fact that are disabled, but there are certain things that are way more difficult to identify. Obviously, cancer is going to be a disability. HIV, major depression, multiple sclerosis, PTSD, bipolar disorder, those are disabilities. But I might be experiencing, for example, anxiety, and it's going to have to be an individualized analysis of whether my anxiety is so severe that it's impacting a major life activity or not, substantially limiting the performance of a major life activity or not. So when I say, yes, there's a list, but there isn't, it's because there is a list of things that, yeah, we know are disabilities, but always, you can never go to that list and be like, oh, it's not on the list, forget it, you're not disabled. You have to engage in that individualized fact-specific analysis. You need to engage with employee's doctor so that they can provide you enough information and an assessment as to whether the person is or is not disabled. And one advice I will give you, we all need to stick to our roles. I'm a lawyer. I'm not a doctor. So I don't pretend to be one. I don't play doctor. If you are in HR, if you're a manager, if you are, stick to your role. We are sending the paperwork to the doctor for a particular reason. We are not the ones who get to say, oh yes, that person is disabled, or no, that person is not disabled. We get to say as the employer, well, he didn't fill out the paperwork. Or we get to say as the employer, hey, I think I might need a second opinion here. But we do not get to just be the doctor ourselves and be like, oh, that's BS. Anxiety, not a thing. I'm not counting that as a disability. Stick to your role. Now, what are the rules about pregnancy? So there has been a lot of talk about pregnancy in the last few months because of recent legislation. Now, under the ADA, federal law, pregnancy is not a disability. Now, could you be disabled while you are pregnant? Sure. For example, a normal pregnancy is not going to be a disability, but if for whatever reason I'm experiencing complications and now I need to be in bed rest, then I am disabled temporarily as a result of the pregnancy. But all things being normal and being a routine pregnancy, that is not going to be considered a disability under federal law. There are states, many states now, that cover regular and eventful healthy pregnancies as a disability. So just look to see what state your employee is in so that you can make an educated assessment as to whether that pregnancy will be considered a disability or not. Now, how do we find out that our obligations to accommodate have been, how are they triggered? Well, very similar to the FMLA issue. If now all of a sudden I'm acting, again, me being an excellent employee, responsive, always on time, all these things, now all of a sudden I'm not showing up to meetings, I'm being incoherent, I am, not delivering results the way I used to, that will probably put you on notice. So again, much like with the FMLA, we do not need keywords and we do not need the employee to come up and say, I am disabled, I have X condition, I need an accommodation. We as employer have an obligation to, again, keep our eyes peeled, ears to the ground, figure out what's going on in our workplace, and be engaged with our employees to identify whether a reasonable accommodation may be needed. So let's say that something has happened. Now I realize that an employee might need an accommodation. What do? I have a conversation with them. Hey, Rocio, I have noticed that your performance has been sleeping. I have noticed that you are not delivering on XYZ. Are you okay? Is there anything that we can do for you? Please remember that under the ADA, you are entitled to a reasonable accommodation if you need one. Here is the paperwork. Document that you sent the paperwork. Then the employee has an obligation to submit the paperwork to their provider to substantiate the need for an accommodation. And then once they do that, we engage in a discussion. Think of it as like family therapy. We all come together, we talk about what's working, we talk about what's not working and how we fix it, right? So I submit my paperwork as employee. The employer evaluates that paperwork, sits down with management, figures out, well, what are the needs of this particular department? What is the employee telling us that he needs from us? And is that something that we're able to provide to the employee without an undue hardship? Now, what the employee needs may just be an ergonomic chair, easy peasy. But what the employee needs may be, a private space, or they may need, an alternative work schedule. They may need, like, the amount of the different accommodations that I come across are very, very, the spectrum is really broad. So we need to engage in that individualized analysis, engage in communications with the employee, with the provider, and with management to figure out what we can do. Ultimately, we as the employer drive the process. So the employee is not entitled to the accommodation of their choice. However, we need to give consideration to the accommodation that they are requesting. And ultimately, we might end up providing a different one that we as employer can live with without imposing an undue hardship. Now, what is a reasonable accommodation? When we're talking about reasonable accommodations, we're not talking about excusing somebody's performance of the essential functions of their job. You need to be able, as employee, to perform the essential functions of your job with or without an accommodation. So that brings us to the point of what is an essential function. And here, I will be careful because a lot of times I find employers say, well, they have this list of 50 things that this employee does, and therefore I think they're all essential. Well, it's not so easy. Does the job description help us? Sure. We look at the job description, we analyze it, and we determine what is essential or not. However, don't think that just everything that the employee does is essential. When we're talking about essential function, we're talking about the core responsibilities of the employee, not something that they do once, every 5 months. So keep that in mind, and don't be engaged in a discussion with management as to, is this really essential? Is this something that really the employee does on a routine basis that we need him to continue doing? If it is an essential function, the employee is going to need to do it with or without an accommodation, with the ergonomic chair or without it, right? So we just have to facilitate the performance and delivery of that essential function. We as employer do not have to excuse the performance of that essential function. So we do not have to eliminate a responsibility from the employee if that responsibility is truly essential. And again, we always take into account whether the accommodation is going to pose an undue hardship. If it is an undue hardship, then it is not reasonable. And if it is not reasonable, we don't have to provide it. And we also look at things like whether it poses a threat. For example, let's say that you have an employee who is experiencing seizures in the workplace, and one of the things that the employee has to do is drive. Well, I'm not going to be able to just let her drive if her seizures are not appropriately managed, because that would pose a direct threat. So we need to consider not just what the employee needs, but also the safety of others outside of the employee. Now, I already hinted at this, how the interactive process works. It's like marriage, like therapy, marriage counseling. Think of it as any healthy communication that you have with people that you love. It's kind of the same with employee, where you engage, you listen, you do not jump to conclusions, you write. Well, with family, we probably are not writing things down, but here we're going to add that in. We do write things down here to document. But the bottom line is you engage, you listen, you use the appropriate words, you do not jump to conclusions. And then once you have all of the information that you need and you have documented everything, you let the employee know what are the accommodations that we're going to be able to provide. And flexibility is key. The accommodation period may expire and the employee might still need some accommodations. Well, we engage with them, we re-engage. We try to determine whether the accommodations that we were providing are still working for them, whether we should explore different accommodations, or whether the accommodation is no longer needed. So that ongoing discussion is going to have to be there. Now, it's critical that we communicate, but you need to involve the supervisor, the manager. You need to look at safety. You need to look at the impact on the operations. And if you are going to say that something is an undue hardship and that you cannot provide it, you better be ready to justify, a year or 2 years down the line, should there be litigation, why it was an undue hardship. Which is why that documentation is so critical, because the reality is 2 years from now, you're not going to remember what was the basis, or you might not remember as well what was the basis of your conclusion. So we need contemporaneous writings that can facilitate an analysis of what the employer was thinking at the time it made its decision, should there ever be litigation down the road. And I'll mention this again, which I alluded to earlier. The only medical information that you're entitled to as the employer is whether it's information as to whether the employee's job related whether the employee has any job related limitations and what are the accommodations. You're not entitled to the underlying diagnosis. So you're not entitled to, and you do not need the doctor to tell you this person has PTSD, this person has, anxiety, this person has cancer. You're not entitled to that information. You might end up getting it because sometimes the doctors provide it, but you're not entitled to it. So just when you receive the paperwork, do not jump to the conclusion of this is not enough. Consult with HR, consult, with your colleagues in HR, consult with your in-house counsel, with your outside counsel to see if the information that has been provided is sufficient under the law for you to now have to provide whatever accommodation you're going to have to provide. So summary, listen, 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 communicate and document, and use a lot of flexibility. Keep in mind that what is a disability is a very individualized analysis. What is a reasonable accommodation is a very individualized analysis. And please never assume that, oh, FMLA is over with, that's it, the employee didn't come back, we fire him. We need to engage in the ADA process. And I know I'm running out of time, but I also want to mention about the importance of following these processes also in connection with workers' compensation. Oftentimes, employees will get hurt on the job and the company thinks, oh, well, this is being submitted to workers' comp, workers' comp handles it. But workers' comp is not a process that is just its own thing. Workers' comp works in conjunction with FMLA and ADA, and an employee's on-the-job injury may trigger obligations on your end to provide FMLA and to provide accommodations under the ADA. And of course, the FMLA leave will run concurrently with any leave that they're getting in connection with the workers' comp injury. But make sure that you're following that process, and make sure also that you do not have a separate analysis that you use when it is a job-related injury versus when it is not. Multiple companies have gotten in trouble, and the EEOC has been looking into this because some companies are using, oh, if it is a work-related injury, I'm going to do XYZ. If it's not a work-related injury, I'm going to follow FMLA and ADA. And that is not okay. We need to harmonize all of these laws. And if there is a triggering event, it doesn't matter whether it's workers' comp related or not. Let me see what else. Remember that accommodation possibilities can be both a change to the work environment, a change to the equipment, or it can be leave. It can be a different schedule. Let me try to see if I can getting a couple of questions before I turn it back over to Stephanie. Somebody asked, what if the job is one that we cannot have vacant? Can we still post and hire as a temporary position? Sure. You just need to have the person back when their leave is over. Okay, what obligation does the employer have if an employee is out of work for an FMLA qualifying reason, but they do not apply for FMLA? Well, that is when I was what I was telling you earlier, that your obligation is you provide the paperwork, right? If they do not submit it, we give them an opportunity to cure. And if they still do not submit it, then you send them that last chance letter saying, hey, you have been out of work, you are not submitting the paperwork, we're going to mark you absent, and our attendance policy is going to apply, which may lead to your termination. And then if after you send them that very clear letter, they still do not comply, then you can go ahead and fire. Okay, this is a good one. How long does the employee have to be back from FMLA before an employer can take an action against the employee, such as terminating or eliminating the job? Well, there's no magic answer, but obviously the closer in time, the more the risk, right? Because in this area of law, there's this concept of causation and temporal proximity. And if you went on leave today and you got fired tomorrow, or you came back from leave today and you get fired tomorrow, the temporal proximity is so close that causation may be implied, and there may be a link there that says, well, that was what caused the termination. the farther apart, the safer you are. That having been said, I, as an employee, I'm not entitled to any advantage for having gone on leave. So if you're reorganizing or if you have a position elimination, you can still do it, but make sure that your documentation is there to be able to prove that that was the reason why the person was terminated and not because of them having gone on leave. I think my time is up, so I'm going to turn it back over to Stephanie. You guys have a ton of questions that I really appreciate and that I will do my best to respond after this meeting is over. Thank you so very much, everyone. Stephanie, you want to do the poll?
Yes, ma'am. I opened the poll up just a minute ago, so you may see if you are interested in that demonstration of Compliance HR, it comes with a 1-week complimentary trial, and we would love to set our team up with you so we can show you things like the paid sick leave report and our rapid reference tools in addition to our handbook tool. So just click yes on that poll if you are interested. You may need to exit full screen mode in order to do so. And you will also be at the top of the hour. So right now you should be receiving certificates if you are looking for credit for this presentation. Should you have any questions, though, you're welcome to jump in the Q&A chat. So I'll leave that poll open until we go ahead and close out the presentation. Rocio, did you have any final questions you wanted to look at?
No, I think we're out of time, and I want to be respectful of everyone's time, but please do feel free to reach out. Would love to talk to you. And as I said, this is what gets me excited. So, I'm here to help you.
Amazing. Well, you did a great job today on the presentation. So thank you very much for pulling this together. I think it answered a ton of questions, and we really look forward to presenting with you again.
Awesome. Thank you for having me.
Of course, and thank you to all who attended.